is Matt Arnold. I'm the Executive Director of For the Bench Colorado, which is a nonpartisan, not-for-profit judicial accountability organization. I won't go into the details of all that. A little bit of the background. A couple of years ago, I formed For the Bench Colorado in order to raise awareness of Colorado voters about issues in our unelected but still accountable by ballot question third branch of government. And according to the Secretary of State's guidance at that time, Bernie Buescher, and legal advice, I filed as an issue committee. Following all campaign finance regulations, meeting all reporting requirements, filing timely, going according to the rules in every instance, was nonetheless sued. A spurious campaign finance complaint was filed against my organization. And in fact, that organization that attacked me was held to have issued a frivolous, groundless, and vexatious complaint. So even though that group filed a frivolous, groundless, and vexatious complaint and was ordered to cough up attorney's fees, here I am a year and a half later and have still not seen one dime of that money to which my organization was entitled. So I am out tens of thousands of dollars in attorney's fees for defending my right to simply participate in the political process in accordance with the guidance that was laid down by the Office of Secretary of State under two different administrations from two different political parties. I'm here to testify both in general and with respect to two specific rules. I'll get to that. But it's very clear that we have some constitutional legal considerations here. I understand that the Denver District Court judge has ruled against expanding the threshold or raising the threshold on reporting requirements for issue committees. I believe that judgment is in error. Obviously, the 10th Circuit Court had a lot to say about that and very clearly struck down that $200 reporting requirement as unconstitutional. I think in general, one might argue, as some of our other people here who showed up to testify have, that in general, imposing these reporting and disclosure requirements are unconstitutional at worst and certainly chilling of free speech at best. Just briefly, relating to the disclosure requirements, and here I'll talk about the specific rule, Rule 20, in support of redaction of sensitive information. For the Bench Colorado strongly supports that rule. I would urge you to expand the criteria for the ability of people to invoke that rule beyond what is written down under considerations of threats to personal safety to also include threats or risks to income and livelihood as well. And the reason I raise that point is because it is particularly apposite to the issue that I ran and the campaign that I ran over the 2010 election cycle. If I had $1 for every attorney who had come to me and said, "You are absolutely right. Our courts in Colorado, particularly the Colorado Supreme Court, are out of control. The courts are not following the rule of law. Something absolutely has to be done about it. I support you. But I can't give you the money that I would like to because I have to practice in front of these judges. I have to worry about my clients considering this as political activity. It would threaten their livelihood and risk their ability to do their job if it was publicly available information, and easily publicly available information in particular, that attorneys had contributed to a campaign that was designed to hold judges accountable. And it goes beyond even the financial contribution aspect. Dan Capel is a very well-known radio host, told me to my face, "Hey, I can't even touch this. I can't even touch this on my radio show for risk of political and financial retribution by clients and judges before whom I practice." So I strongly urge support of Rule 20, the ability to redact personal information from public view, and would urge again the expansion of that definition to include risk and livelihood. And I have one question regarding that. The timing of the request. I understand that it is the contributor who must file that. At what time would they file that so that it wouldn't pop up on the website only to have to be taken down later. Would that be filed with the contribution? Would it be filed during the report?
Let me say this, just so the record reflects. I want people to know that I, in my prior practice, represented Clear the Bench, Colorado.
It did a damn fine job.
And, but I guess along those lines, I no longer represent you, so we're not going to answer that question today. I would be very hesitant for anyone from this panel to be able to answer that specific question that you posed towards us.
Okay. Yeah, it certainly is an interesting question.
But along those lines, I would say, if you're finished,
Not quite.
okay,
there's
I'm
more.
sorry, go ahead.
I didn't promise to be as brief as Ryan called. Another question, in contrast to the anecdotes provided by the person from the New Era, Colorado, there is no compelling interest to ensure disclosure of this information. Studies have shown, in fact extensive studies have shown, that people are actually not influenced by knowledge of who supports or opposes a ballot measure. There's been extensive research on that, and I'll try to find some of that and send that in as additional written comment. Because of that, and particularly when applied to small individual contributions. Again, as someone else pointed out, the rationale for Amendment 27 was to limit undue influence by wealthy individuals. Clearly, a $10, $20, $50 contribution in the course of a statewide campaign is not an exercise of undue influence. Yet the burden on the organization to collect that information and then report it is rather burdensome and is an undue extra effort or extra work to that person. These requirements, because of that, are essentially imposing a poll tax on political contributions and a poll tax on political participation. That is very constitutional and legally troublesome. Just to address a couple of practical points, and I'll try to make this brief. Again, a couple of people have talked about how these disclosure and reporting requirements tend to restrict political activity, both by organizations wishing to get involved and by individuals wishing to contribute, because of the fact that people are concerned about their information getting out there in public, because the people are having to meet not only the knowledge barrier to entry, understanding all of the very complex reporting requirements, filing deadlines, and the legal issues involved, but there's also a financial barrier to entry, because this is a fair amount of time and or money that has to be spent on collecting, collating, and reporting all this information. The other big issue, and I disagree with the previous witness here that said that the big money groups are not represented in this room. Actually, most of the people here, many of the people here, I would say, certainly are the big money groups. Progress Now Colorado. I'm not sure how big money Mi Familia Vota is, but certainly Colorado Ethics Watch is. They receive quite a bit of money from in-state and out-of-state large contributors. The Democratic Party, the Colorado Judiciary Project, which is an organization that played in the political arena but didn't even bother to file as a committee and was not subject to any reporting requirements whatsoever. Mi Familia Vota, New Era, Colorado, all of these groups are very active in the political process, yet these disclosure and reporting requirements do not apply to them. I find that rather problematic. And again, it's marked. It's just absolutely amazing how all of these groups that are not subject to these disclosure and reporting requirements themselves are the only ones advocating for stricter disclosure requirements, for more reporting requirements, for more openness and transparency for the other guy. Again, I find that very problematic. One of the big issues is the lack of clarity and consistency in applying these rules. Because of the fact we have these gray areas, the $200 contribution limit is clearly unconstitutional. So what is constitutional? At what threshold does the state have a compelling interest in collecting that information? I think the $5,000 threshold is reasonable. For that reason, I support Rule 4. But at this point, because of this legal gray area, every group in Colorado wishing to speak out on political issues or ballot questions or anything else is at legal risk. And I find it not only problematic, but deeply offensive that Senator John Morse testifies, well, that's just the price of participation. That you just have to go out and hire a lawyer to exercise your right of free speech. I find that troubling and, quite frankly, offensive. And on this date especially, as one other person pointed out, I'm glad they did, the 220th anniversary of the ratification of the Bill of Rights, the First Amendment to our Constitution. Number one, for a reason, free speech shall not be abridged, is at risk because of this ambiguity and the existence of politically motivated, well-funded, non-transparent groups with the sole purpose in life of harassing small groups and individuals that wish to participate in the political process is deeply troubling and indeed offensive. One quick point to rule, was it 17.4, the one about the 2-week reporting issue? Again, leaving that open, having that ambiguous situation continue through until the legislature gets around to dealing with it by May 16th or whenever, is again deeply problematic. It puts anyone who wishes to participate in the political civil process from now until the legislature gets around to making statutory changes at risk. Conversely, it also puts the state at risk, because the state can and quite frankly should be sued for failure to uphold the Constitution on this issue. A Sampson v. Busher could proliferate. We could have a dozen of those, each costing the state upwards of $500,000. The fact that this legal ambiguity is allowed to continue is deeply problematic and troubling, both for the individuals and groups involved and for the taxpayers, quite frankly, who are ultimately at risk from all this. And finally, just to summarize and kind of wrap up, the fact that these campaign finance reporting and disclosure requirements, had they existed and been applied during the 1960s, would have shut down the civil rights movement because of the legal expertise that would have been required, because of the reporting requirements that would have been required, because of the disclosure on contributors and participants. All those people would have been subject to threat of life, limb, or property. And although the situation has certainly changed somewhat for the better, we don't have to worry about water cannons and attack dogs and truncheons being applied to people wishing to exercise their free speech rights in this country at this point. We do have to worry about discovery and lawsuits and campaign finance complaints and having your property and your livelihood put at risk due to politically motivated campaign finance complaints. And I believe Paul Shade also mentioned that study in Florida that pointed out, I believe it's the Florida Secretary of State, had done a study, and I would urge you to do a study as well, that 98% of campaign finance complaints were politically motivated. Clearly, there is an uneven playing field when groups that are participating on one side are subject to these politically motivated attacks, whereas those who are advocating for more free speech don't, because philosophically they believe in an open exchange of ideas, don't go after the other groups and or don't have the secret resources to go after those groups on the other side attempting to take more of our rights away through the same process. That concludes my testimony. Any questions?
Mr. And I see Ms. Shays walking out, but I will, just one moment. I just want to make a comment. Rule 20 is merely moving the location. That rule's been around for a while, the anonymity issue, for fear of retribution. As far as the standards for implementing it, and if you have other ideas, I don't necessarily want to engage in that conversation right now, but I'm a little surprised I've gotten comments on this one, just because it's a recodification. But look, if you think there should be a different standard, and including the mechanics, how someone makes the case to the Secretary of State and how we respond, the timing, the evidence of proof, I appreciate any thoughts you have in written comments, because I don't necessarily want to delve into that here.
Right.
before the close of the period, just because I hadn't expected anything on this, but if you do have comments on the details, I'd be very
I'll
interested.
be happy to supplement an additional comment with some ideas on the mechanics.
Thank you very much. Thank you.